Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. This morning we have two dockets. We have an announcement docket and we have our hearing docket. Those of you who have attorneys, when we call your name, please come up to the bench with your attorney. And those of you who do not have attorneys, when we call your name, you just come up to the bench by yourself. Okay, first case we have, let's see, they have sent us in on cause number 23 CCCR 1888. Case of style of state of Texas versus Ryan Paul Barrett. Mr. Barrett, would you please come forward? Mr. Gregory, you should come forward as well. He's on two dockets. Okay, Mr. Barrett, your case originally set for sentencing. Your attorney, Mr. Gregory, filed a motion for reconsideration. Now, Mr. Barrett, how are you doing?
Doing wonderful. How you doing?
I'm doing fine. Thanks for asking. Mr. Gregory, how are you doing?
Fine, Your Honor.
That's good. State is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
I'm doing well, Judge, and yourself?
I'm doing fine. Thanks for asking. Mr. Gregory, I read your motion for reconsideration. State, did you receive a copy of Mr. Gregory's motion?
I did, Your Honor. I've reviewed it.
Okay. Now, before we go any further with this motion, I do note that in the motion for reconsideration, you noted that pursuant to the case of State versus Davis, 335 Southwest 3rd, 252, stating that the motion for reconsideration is actually equivalent to a motion for new trial. Is that correct?
That's what the case said, Your Honor.
Okay. And I do know that I'm just trying to figure out how we should handle it. Normally, motions for new trials are filed 30 days after sentencing. This was filed before sentencing. So it would appear that it could be premature.
I would argue that the court could always reconsider its verdict at any time. There's no set time limit. I would be surprised if there's any case law that says that the court cannot reconsider what it's done and enter a different verdict at any point in time.
Okay, so you would like the court to proceed with this motion before sentencing? That's what you're saying?
Yes, Your Honor. I would like the court to reconsider.
Okay. Now, I read your motions. Would you like to have an argument associated with this motion, or you would like the court to rule based on the arguments that you made in the motion?
Well, I would like to make a few remarks regarding
Okay,
that.
you may proceed.
Of course, any court is going to, when it's a bench trial, of course, the court is the last place where evidence is decided. What amount of evidence is sufficient? What does the evidence say? What evidence is important? And a court must question itself in rendering a judgment and finding a person guilty and ask, did I give too much weight to one piece of evidence? Did I give maybe insufficient weight to something else? These are important questions that a court ought to ask itself. And if a reasonable doubt exists, did I overlook something that created a reasonable doubt? And because the last thing any court wants to do is to find an innocent person guilty. And that's why I asked the court to examine itself today and ask what critical evidence was there, and does it point to a reasonable doubt? A reasonable doubt, one reasonable doubt, not all doubt, but a reasonable doubt, one in which the court might weigh out and say, is this really, did it really happen? Ask yourself, Your Honor, is there a reasonable doubt that Mr. Berry did this, did he make these statements? Recall that there was a video recording of this incident, that the complainant's husband actually took this video. And listen, and in this video, if you would go back and listen to it, you would hear there are classroom noises. So we know the audio person, the microphone, picked up what was there. And her husband testified, I heard him speaking, but when you listen to the video, there's nothing on the video. There's no audible sounds coming from this man, just basic classroom noises. So ask, did I overlook the fact that if Mr. Barrick actually spoke those words, would it have been heard on the video? That's a reasonable question to ask. And if you did not hear Mr. Barrick's voice on that, how did Mr. Thornton hear it? Mr. Thornton said, I heard it. He took the video with his phone. Now, is his phone any closer to Mr. Barrick than his ears? They're not. If Mr. Barrick said those things, then it would have been on the video, but it was not. Also, did I overlook and then I point this out in my motion. Mr. Barrick was supposed to have said something to the effect was, this is your one chance to have him leave before I hurt you, little girl. And I would challenge the court, visualize yourself speaking those words. How would your mouth move? How should Mr. Barrick's mouth have been moving? But when you look at that video, his mouth's not moving. So how did he say what he was alleged to have said if his mouth is not moving? Certainly that would raise a reasonable doubt with this court that he did not speak those words. There's an irreconcilable difference. Mr. Thornton says, I heard him say words in the video. Well, we assume that it's not been tampered with and that it's presumed to be the good evidence. Why would he not have been on that video? Another thing, there's no reaction by the victim. He is as close as I am to him. And you would have expected if he had made that statement to her, there'd have been a head whip like, I can't believe this man's saying this. But she acts as if he said nothing. Why? Because there's a reasonable doubt that he said nothing. And I want the court to weigh out. The last thing a court should have is an innocent man found guilty when there was a reasonable doubt, and question itself later, did I allow a reasonable doubt to stand and find the person guilty, knowing there is a reasonable doubt? And so I would just ask the court that you look that he needs to be found guilty beyond a reasonable doubt. The evidence establishes some reasonable doubt, Judge. And I implore you to reconsider and enter a not guilty verdict, acquit this man.
Mr. Hill.
First, I'd like to start by saying that this is a motion to reconsider and specifically talking about reconsidering the evidence in the video. So we're not here to relitigate the entire trial. Defense has already made the argument contained in these motions, like throughout the trial and during closing. and specifically regarding the video and what they maintained that his mouth wasn't moving. After closing, you made a careful review of the evidence, even taking the matter under advisement and coming back the next day to pronounce the verdict. This is not a verdict made arbitrarily or unreasonably. It was one made after giving the evidence and testimony in this case due time, attention, and examination. And I don't see any factual or legal basis to reopen the guilt innocence phase at this point to review the evidence.
Yeah, anybody have anything else?
The mark of a good jurist, a good person, is to be able to question themselves. And if they saw it wrong, they overlooked something, and recognize it and correct that so that a wrong would not be done to an innocent man.
Okay, your motion be denied. The court did reevaluate the evidence. Court reviewed video, reviewed transcripts, judged the credibility of the witnesses. And of course, the ruling was based on the law as it applies to this case. So at this time, we will now proceed with the sentencing. Mr. Gregory, did you receive a copy of the pre-sentence investigation report?
Yes, Your Honor.
Have you reviewed that report?
Yes, Your Honor.
Do you have any objection to the findings, conclusions, or recommendations that's contained in that report?
Object to the rendition of the offense that's in the pre-sentence report is based on hearsay
Okay.
from the police officers and had nothing to do with the testimony that this court considered. There were no police officers that testified. And I would ask that the court completely disregard the statement of the offense. Would also like to point out that the pre-sentence investigation regarding probation recommendation, it simply said that if probation was to be imposed, that he would be a suitable candidate. This court does not have to impose probation, and the pre-sentence report did not recommend probation. It only said that if court was going to place him on probation, that they would make certain recommendations. I would ask the court that having found Mr. Barrett guilty, it would impose a fine, and that supervision is not necessary in this case.
Mr. Hubel, do you, let's see, have you received a copy of the pre-sentence investigation report?
I have, Your Honor.
Do you have any objections to the finding conclusions?
I do not.
Okay, let's look at it.
The other is the author of that report present, that we might question that person.
Hold on a minute. Let me see, trying to get to the next page. Let's see, you talking about the probation officer? Let's see, Judy Lindley. I don't think Miss Lindley is not here, is she? We can get Miss Lindley here. She's at the probation office, which is a few blocks away from the courthouse. You want us to go ahead and get Miss Lindley?
No, Your Honor, let's proceed.
Okay.
Your Honor.
Yes.
I have one witness that I plan to call, if it'd be appropriate to do so.
Okay, this is punishment. You like to call a witness?
Yes. But
Your Honor, I don't see no reason to do that. I object to that. The court ordered a pre-sentence report for that input.
But this is punishment, so this is like the punishment phase. So in the punishment phase, witnesses can be called. I mean,
It's your court, Your Honor.
that's the law. Okay.
prior to doing,
What witness are you gonna call?
I was going to call Delaney Thornton, but prior to doing so, Judge, I just want to make sure that she's here currently.
Okay. You need to see if his witness is here.
I didn't know exactly what time to tell them this morning. that
Oh.
they were going to carry on it. I just told them that it was going to be.
Is this? That's- Okay. Mr. Hill? You have another witness?
No, Your Honor, if you give me a moment to contact them, I think that they are present at the courthouse. But I just need-
Okay, we'll give you a little time to
Thank you, Judge. It'll only take-
contact, okay. You need, so he need to get in here and sign it? Is it a way for him to get in, or would I have to, would he have to use my? Okay. Oh, he can. Okay. Judge Ron is getting ready to. Do you have his docket? Where is he?
All rise.
Dr. be seated, thank you.
Let me get that guy out. I don't get him the whole thing. This is his dismissal. I guess see that.
Oh.
We just name it information. Yes.
Marvin Lewis Junior, is that your correct name?
Yes, sir.
All right.
That's his attorney.
Huh?
His attorney is Marvin Lewis Jr.
Oh, I'm sorry.
Mr. Knight.
Sure.
Jaden.
name is Jaden Knight.
All right. I'm sorry, your correct name is Jaden Knighton?
Yes, sir.
Okay. And I believe that the state is moving to dismiss this case. All right,
Yes.
all right, the court then will follow the motion and will dismiss this case. And I guess he's free to go. Legally.
It's on the back. In the back. Memorize it and it'll be sent to the child.
Okay, I'm through with this.
Yes.
Okay. And he's, I guess, he's free to go. Huh?
Yes. You can go back.
You can go back to this.
All right. Okay.
Yes.
Okay.
All right. County Two Court back in session.
Okay, y'all may be seated. Okay. Mr. Hill, you ready?
Yes, sir.
Okay. Court is back in session and cause number 23 CCCR of 1888. Case of style, State of Texas versus Ryan Paul Barrett. Mr. Barrett, you may come forward. Okay, Mr. Hillble,
City calls Delaney Fortin.
Delaney Fortin.
Delaney Fortin, yes, Your Honor.
Okay. Would you please call Delaney Fortin? Ms. Fortin, you may come forward. Ms. Fortin, would you please raise your right hand? Ms. Fortin, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Ms. Fortin, you may put your hand down. Mr. Hillble?
Is it okay to conduct questioning now?
Yes, you may proceed.
Thank you, Your Honor. No, you testified, in the guilt and innocence phase of this case, as the complaining witness, correct?
Yes.
And are you aware of what happened with that, Mr. Ryan Barrett was found guilty? Now, since that verdict, have you had interactions with Mr. Barrett?
He
Since it-
came up to, so he found out that my kids had the therapy appointment when I had them. The therapist accidentally sent him a notification about it. So when I went up to the school to pick them up from school, he made sure he was there at the school when I was there to go get them. He's also seen his girlfriend's vehicle.
Where,
drive
so
past our house.
let me ask you this. Have you had repeated contact with him? During some of these contacts, did he drive by your home.
Yes,
Did he use this as an opportunity to follow you and your husband?
yes,
Um, would you consider this behavior to be harassing in nature?
yes,
Um, Did it alarm you? Did it scare you?
yes.
Are you still scared because of that? Are you worried about what he might do if this behavior continues?
Yes.
No further questions, Your Honor.
Okay, Mr. Gregory?
Ms. Thornton, isn't it true that there's a current case pending before the district court in this county that alleges that you have abused your children, and it was filed by Mr. Barrick, and he's seeking to have greater custody in
Object to
this
relevance.
case?
Well,
I'm also seeking.
before you go any further, you object to relevance, right?
Yes, how the pending case regarding your children is relevant to his continued, like harassing behavior. But
Okay. Now, Mr. Gregory, what's your response?
My response is it goes to her motivation to make these statements, which are not being put accurately to the court. And she's trying to use this court to elevate her position in another court, which is why I urge this court to reconsider its finding earlier, is that this is a miscarriage of justice that she is putting upon this man, trying to make it look like he's the bad guy, when the petition before the court is that she is the one that has done something that is improper.
Okay, your objection is overruled. You may proceed.
Okay, now, isn't it true that you've got this, you need to answer the question that I asked. Okay.
Yes, he.
Oh,
harassed
Miss,
me
hold
with
on,
that.
Miss Thornton. The attorney will ask questions. Please do not answer or do not respond until he finishes asking his question, okay? You may proceed, Ms. Gregory.
As I asked before, isn't it true that there is a petition filed by him alleging child abuse against your children?
Yes,
And isn't it true that you know that if you get a adverse finding in this court, that it will make you look better before Judge Shelton?
No.
You don't believe that?
No.
Okay.
this, whether he's found
Now,
guilty or not.
On the date that, again, I ask that you answer the questions only that I asked. Would you instruct her not to make additional comments, Sean?
Okay, now, Ms. Thornton, please do not only answer the question that's asked, okay?
Now, on the date that you just mentioned about him being at school, did you have any knowledge that he was at a parent-teacher conference prior to you coming up to the school?
He knew I was gonna be there.
I did
I didn't
ask,
know.
that is a yes or no question. Did you know that he was at a
No.
parent-teacher conference? So what you're alleging to the court here is that he found out and he came up there just so he could aggravate you, when in
Yes.
fact he was up there for a parent-teacher contract. Is that correct?
Yes,
Okay, Your Honor, I would just argue that she is again trying to misuse this court to get to him in another matter.
You finished,
I pass the witness.
Mr. Hubel?
State has no further questions for this.
Okay, Ms. Thornton, you excused?
thank you.
Okay. Okay. So state you have no other witnesses,
That's correct, Your
is
Honor.
that correct?
One of, the only other thing the state would, is that, the state asked that all evidence and, admitted at trial for guilt innocence purposes also be admitted for purposes of punishment.
Okay, that'd be great. Now the court will, take, judicial notice of the court's file. The, and the pre-sentence investigation report will be accepted with the note that the defense is objecting to the police version that is in the PSI. No police officers in this case testified. I think the only witnesses was Miss Thornton, her husband, and the defendant. Okay,
That is correct, Your Honor.
all right, now, Mr. Gregory,
Yes, Your Honor.
you were asking the court, obviously, to assess punishment within the punishment range, and you're asking for a fine only. Is
That
that
is
correct?
correct, Your Honor.
All right, and state, what is your recommendations?
My recommendations are twofold, Your Honor, is if you can see, look at the PSI, the statement of the complaining witness, for the reasons that she just testified to and for the, like, foregoing issues, she's concerned about her safety and, wants the victim to, the defendant to have, sort of a moment to recognize like his behavior is incorrect. So the complaining witness would be asking for a short period of incarceration. Now, in the alternative, and since I recognize the defendant's limited criminal history, the state would be also requesting if the court does not wish to give incarceration, a probation with an anger management requirement and a requirement that the defendant have a GPS device, as well as no contact with the complaining witness outside of matters concerning custody.
Your Honor, I would suggest to the court that based on the complaining witness's testimony a few moments ago, I would hope the court would recognize that she's going to look for the worst in Mr. Barrick. He's at the school for a parent-teacher conference, and she assumes that he went up there to harass her. Her testimony is greatly skewed only in her direction and is not balanced with the facts. I'd ask the court to recognize that she's going to think that he's the boogeyman who's out to get her, when in fact that's not true at all. And there's no evidence to support that. And there's no reason for him to have supervision.
And I would reiterate the fact that the court has, as the sole decision maker of facts and law in this case, has decided the facts in this case and found the defendant guilty of harassment. And the testimony from the complaining witness here today has shown that this behavior has continued and there are no signs of stopping without some kind of intervention from the criminal justice system.
Again, the alleged continuing behavior is only from her misperceived conclusions. He's at the school, oh, he's out to get me. I'd also like to point out to the court that her husband was recently found guilty of threatening this man, and the court heard the video and knows that he avowed that he was going to make his life a living hell. These people are out to get him. And you have the power to balance that scales of justice, and I ask you to do that, Your Honor.
Okay, let me do this. Okay, I was looking at his the PSI in terms of criminal history. He has none other than this case that we're here today on. He doesn't have any no misdemeanors, no felony convictions or anything of that nature. He is gainfully employed. He's still employed.
Yes, Your Honor, he's employed through the Department of Defense and Department of Energy with the federal government's agencies.
Okay. Apparently, he doesn't have no either. He doesn't have any issues with drugs or alcohol either. Now, based on, the comments that Mr. Gregory made regarding the PSI, the probation office does not necessarily make recommendations. They just let the court know whether or not a person is a suitable candidate or is not a suitable candidate for probation, but they don't necessarily make a recommendation for the court to follow. Let's see. Let me do this. Okay, this is a Class B misdemeanor. Let me do this. I need a little bit more time. Decide what punishment is gonna be in this case. So, I'm gonna take this, we're gonna take this matter under advisement, okay?
Yes, sir.
All right,
Thank you, Your Honor.
okay,
Appreciate that.
okay. Give him a reset.
June 12th.
No, that's fine. Well, whatever, just find out about his schedule, their schedule. We got Mr. Allison. Is, Shayna Levine Gregory? Okay.
This is good.
Okay. Okay, this is cause number 23CCCR 2582. Case of style of state of Texas versus Shayna Levine Gregory. Ms. Gregory, is that your full name? How are you doing, Ms. Gregory? I'm doing fine, thanks for asking. Ms. Gregory, you're represented by your attorney Terrence Allison. Attorney Allison, how are you doing?
I'm fine, thank you.
That's good. Mr. Allison, what is your announcement in Ms. Gregory's case?
We will be asked to be placed on another announcement
Yes.
docket. I did it with the prosecutor. There's some documents I need to get to him. I have received discovery.
Okay. Give us a reset date.
June 12th.
Thank you. June 12th.
June 12th, 2024. Once you get your reset from your attorney, you're free to go. And Mr. Alice, this is the other case?
That's it.
You're free to go
Thank you.
as well. You have a blessed day.
All right.
Y'all have a blessed day. Uh, Nathaniel Allen. It's a judicial review. Hey, this is cause number M327829, case of style of state of Texas versus Nathaniel Allen. Mr. Allen, is that your full name?
Sir,
How are you doing, Mr. Allen?
I feel blessed right now. Got a lot of things going on today, and just man, I'm gonna be with
Okay. Now, Mr. Allen, your case is set for a judicial review.
Yes, sir.
Okay, hold on a minute, let me pull that up. Are you Miss Richard? Okay.
Ms. Carter.
Barthon? Okay. Yeah, I was looking for, see if there was any paperwork. Let's see, for the next page. Population. Semester, administrative. Plan. Here we go. Second. Okay. Check it. Okay, Ms. Carton, you're with the probation department? How are you doing? I'm doing fine, thanks for asking. Attorney Erica Porter is with the Jefferson County District Attorney's Office. Ms. Porter, how are you doing?
I'm doing great, y'all, thank
Okay, and Ms. Porter, you like to proceed?
Yes, y'all, we would.
Okay, you may
Okay, so
proceed.
After speaking to the probation department, I've been made aware that the defendant has been reporting as required. He has accumulated 80 hours of community service. He's a little short, 68 hours behind. He does own his fees because he's not working at the moment. And he needs to do some type of substance abuse. And we're actually recommending for an extension of probation and put it on a high needs case load. And that's based on the recommendation of probation department as well.
Okay, let me look at his file.
Okay.
He was originally placed on probation on September 27, 2023.
Correct.
Okay. And that probation was for 1 year? Okay, that was for 1 year. Okay, so you were asking for an extension?
Yes.
How, was it a year, 6 months? What type of extension?
I would say at least a year because he has not found employment. But it's my understanding he was looking for employment, but he hasn't obtained employment yet. So he's not able to catch up on any of the fees or and give him enough time to at least do some substance abuse treatment. He did test positive recently for marijuana, I believe, and THC and benzo. So we want to give him time to complete a program. Some type of substance.
Okay, now, Mr. Allen,
Yes, sir.
you're currently unemployed?
Right now, until I go to this interview.
Okay, now how? He's ordered to pay fine and court costs, right?
Mhm.
And what's the total of that?
Last court date, you converted those to community service.
I did?
Yes, sir. Yes.
Okay. So his fine and court costs was converted to community service.
Yes,
So the only thing that he has is left is
probation.
the probation fees.
And a $250 attorney.
Okay,
Mhm.
how far is he behind on his probation fees?
Right now, 6 points.
And if we extend his probation, we are asking, for the probation fees to be assessed.
No, sir.
Okay, so you will not assess any additional probation fees,
No, sir.
okay? And now, I think pursuant to, is it Articles 26.05, I think it's 2605 G1-1, G-11. The court can waive the attorney's fees. 26. Yeah, here we go. Yeah, 26.05 is the subsection only the defendant who at the time of sentencing to placement of the pay maximum at any time during the defendant's sentence of confinement or period of release, the judge written notice to the defendant and the defendant to present information of what they may order the defendant. Portion. Okay. Now, the court can amend the order regarding the attorney's fees pursuant to Article 26.05 G-1 3. Okay. And so what the court is, in view of the fact that he is indigent, the court is going to waive those attorney's fees. Okay. So you will not be required to pay the attorney's fees. However, you still will be required to pay the balance that you owe on the probation fees. Okay. And whatever balance you have on your community service, you have to complete that. And the court is going to extend your probation for a year. Okay. And we're going to start from I think his probation was due to end September. Let's see, his probation was due to end September 26, 2024. So it's going to be an extension of September 27 of 2024 for a year. Okay.
Okay.
All right. So do you have one of those forms? I think Mr. Gilliam usually have a form that he has.
Also, your honor,
Yes.
I just,
Oh, and also drug treatment. You need to be in drug treatment. What I'll do is, one, you're gonna be required to attend AA-NA meetings 3 times a week. Okay. And then what other program that we have, we could make them attend ATAR through Spinotop Addiction Treatment and Recovery Program. Okay. Now, the money that you use, you're not supposed to be using that money to buy drugs.
No, I don't.
And they're not giving drugs away free, okay?
I don't understand that, but I'm not.
Well, somebody has some money for it.
That's it.
Well, nobody's going, so put it like this here. You know and I know, it ain't, drugs ain't free.
Exactly.
Right. So you're getting money from somewhere to buy the drugs. I don't know if you're asking for money on the street I don't know where you're getting it from. But you're gonna have a zero tolerance. All right? Zero tolerance means no drug use. You use drugs, you just your probation can get revoked. All right? All right. Therein lies the problem. If we could solve that problem, the other problems that you have in the criminal justice system probably will go away. Okay, I know they advertise drugs on television as being something that, everybody's always happy and joyous, but it ruins lives. Okay. So he's going to be doing drug treatment. He's going to go to ATAR and he's going to do AA-NA meetings 3 times a week. Okay. And I just needed an order, if you can draft me up that, probably get with Mr. Gary Gillen, he has that form, it's a form that y'all can. And, okay. Yeah, Jennifer probably know what I'm talking about too. Okay. All right. And so just have a seat. We're gonna draft that order. We're gonna call you back up, and then we'll amend and extend your probation. Oh, Mr. Jeffers?
Yeah, here we approach again. I mentioned high needs caseload and probation.
Come on back up. It's Mr. Allen. Okay.
Probation department is concerned and would like for him to be placed on a high needs caseload. And I kind of mentioned it, but I don't think it was addressed. So I didn't
I
know.
just found out that, about a few weeks ago that he's homeless and unemployed. So
Oh,
the high needs caseload, I feel like he would be more appropriate for that because she can assist him.
okay, okay. And the folks that, yeah, that phenotype will be able to help him with that too. Okay, we'll put him on a high needs caseload. All right?
Okay.
All right. We're gonna have Mr. Jeffers client. Mr. Jeffers?
Thank you.
Court is in session in 3 cases. Cases are cause numbers 23 CCCR 1516. Cause number 24 CCCR 0286. And cause number 24 CCCR 0232. All 3 cases are styled the state of Texas versus Larry Ben Green Jr. Mr. Green, is that your full name?
Yes, sir.
How are you doing, Mr. Green?
So,
I'm doing fine. Thanks for asking. Mr. Green, would you please raise your right hand? Mr. Green, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
yes, sir.
Okay, Mr. Green, you may put your hand down. Mr. Green, you also represented in this case by your attorney, Attorney Benjamin Jeffers. Attorney Jeffers, how are you doing?
Doing well, Your Honor. Thank you.
That's good. State is represented. Now, Mr. Jeffers, do you waive a record in Mr. Green's case?
We do.
Okay. State is represented in this case again by Ms. Porter. Ms. Porter, how are you doing? Just, he can go in the back room and talk. Okay. We can hear, just, if you need to talk to her, just go in the conference room.
still talking.
Okay. Now, I see him. He has 3 cases. I only see 2 cases on
I
here.
dismissed one. I submitted it.
It's already dismissed?
I dismissed it. I submitted
Oh.
dismissal for you to dismiss.
Oh, okay, I didn't see it on here. Now,
You don't see it?
Mr. Green, in cause number 24 CCCR 0232, I have before me an information that was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Larry Ben Green Jr., on or about December 22nd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of violation of a protective order. Mr. Green, do you understand the state's, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Green, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Green, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Green, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Green, are you a citizen of the United States?
Sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into evidence?
Yes.
Any objections?
No objection.
No objection. State's Exhibit number 1 will be admitted into evidence. Mr. Jeffries, you've advised and counseled Mr. Green. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Green, your attorney, Mr. Jeffries has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Green, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of guilty, the state has offered 60 days in Jefferson County Jail, giving them credit for 60 days, time served, tax and retire court costs. We're also going to dismiss cause number 23 CCCR 1516.
Okay, Mr. Green, the state is offering that you serve 60 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 60 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case, Mr. Green, will be taxed and retired. It simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. This case will also run concurrent with cause number 24 CCCR 0286, and the state will be dismissing cause number 23 CCCR 1516. Mr. Green, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Green, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Green, I'll proceed to your next case. Okay, Mr. Green, your next case is cause number 24CCCR 0286. And in this case, I have before me an information that was filed by the Jefferson County District Attorney's Office. And in this information, Mr. Green, it alleges that you, Larry Ben Green Jr., on or about January 25th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of violation of protection order, a protective order. Do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Green, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Green, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on a, well, there's a signature on a line next to a box that's checked guilty. Did you place your signature on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
There are 2 boxes checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you recognize, but do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. You recognize this document? And is this your signature on the line that's titled defendant? And Mr. Green, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, would you like to offer State's Exhibit Number 1 into evidence?
Yes, yeah.
Any objections, Mr. Jeffries?
No, Your Honor.
No objection. State's Exhibit Number 1 will be admitted. And Mr. Jeffries, you're advising counsel, Mr. Green. In this case, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Green, your attorney, Mr. Jeffries, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Green, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, yeah.
And what is that agreement?
In exchange for the defendant's plea of guilty, the state is offered 60 days in Jefferson County Jail, giving him credit for 60 days, time served, tax and retired court costs. We're also going to dismiss case number 236 CCCR 1516. And this case is going to run concurrent with 24 CCCR 0232.
Okay, Mr. Green, the state is offering that you serve 60 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you'll be given credit for the time that you have already served. The court costs in this case, Mr. Green, will be taxed and retired. That simply means that you will not be required to pay it because the time that you spent in jail has already paid it off. And the state will be dismissing cause number 23 CCCR 1516, and this case will run concurrent with cause number 24 CCCR 0232. Mr. Green, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Sir.
Mr. Green, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Green, this will conclude your cases. If you do not have anything else holding you in jail, you should be getting out of jail today. Okay?
Yes, sir.
Now, Mr. Green, these cases, we had a revocation, I think it was the bond revocation hearing, they had originally set in these cases. Under no circumstances should you go to that lady's, house, okay?
Yes, sir.
Now, I would know one thing, that, this is my second time seeing you here from the first time we had the revocation hearing. And I could tell by the confidence on your face, you look a whole lot better. Okay? So apparently, I think your system has been cleaned out. Okay? So, if you, so just continue to stay on the road of sobriety. Okay?
Yes, sir.
If you need some help, there's some help in the community. A lot of agencies that's in the community that can help with you being sober.
Yes, sir.
Okay? All right. So you're gonna follow the directions of our bailiff. Once you finish following her directions, you can follow her, and you can be free to follow her, and and you have a blessed day.
You too.
And Mr. Jeffers, you have a blessed day as well.
Yes, Sean, I was gonna cover for Ryan.
Ryan
He
Gertz.
has one. Lives it. Andrew.
Oh, I think he was on Zoom. Hold on, he was on Zoom. Hold on a minute. All right. Okay, so we have, hold on, I think he was on Zoom. Let me get him back on Zoom. Yeah, okay. Andrew Ledzik.
Yes, Your Honor.
Okay. You represented in your case by your attorney Ryan Gertz. However, Mr. Gertz is not here today. Standing in for Mr. Gertz is attorney Benjamin Jeffries, who's an associate with Mr. Gertz. Does he have your permission to stand in for attorney Ryan Gertz?
Yes, Your Honor.
Okay.
I'm not sure I feel totally comfortable with that. I haven't had a whole lot of contact with my attorney over the past several years. So I'm just not very familiar with how this
But
how this
he's
would proceed.
he's an associate with the Gertz law firm.
Okay.
Right, attorneys can't be in two places at one time. Apparently, he may be in court in another county. And so he can't be here. So he has his associate here making the announcement that he was going to make on your behalf.
I understand, Your Honor.
Okay. So is it all right for Mr. Jeffries to stand in for Mr. Gertz?
Yes, Your Honor.
Okay. Mr. Jeffries, what is your announcement in Mr. Ledzik case?
Yeah, Mr. Gertz is asking for a reset in this case.
Oh, he is? Okay. How much time does he need? Did he a standard reset?
Yes, sir.
Give us a standard reset. Okay, now, this case is gonna be reset to June 12th, 2024. Mr. Kledzik, stay in contact with Mr. Gertz's office, or Mr. Gertz, and stay in contact with your bondsman, okay? You're free to go. Thanks for being patient with us. I know you were here, actually, you was here first on on Zoom. When we turned the Zoom on, you were already here. And then at some point, you got off of Zoom and then got back on. All
Yes,
right.
Your Honor. My connection is a little fuzzy.
Okay, so stay in contact with your attorney. You're free to go, and you have a blessed day.
Thank you, Your Honor. Your Honor, one thing, would you consider a dismissal of this case?
Well, your attorney can tell you the law about how dismissals work. Okay?
Okay.
So get whatever legal advice you need to get it from your attorney, Mr. Gertz. And again, this case is reset June 12th, 2024. Okay?
June 2024. Thank you, Your Honor.
All right, at 9 a.m. All right.
Okay, have a good day.
Same to you.
Thank you.
Next case is cause number 23CCCR or 2576. Is that,
William Jones.
that's William Jones?
Yes, Your Honor.
I used to represent him. Isn't that correct?
Sir.
Yeah, so we got a conflict, so we're gonna have to transfer this.
I understand, Your Honor.
Yeah. It's been a while.
And I had,
Okay, so what we're gonna do,
that connection with your staff at the time, but that's fine.
yeah, it's been a while. Yeah, we need to, I think that might be back in the 90s. It was a while back. I know it was a while back. Yeah,
He's gonna move it.
we're gonna have to transfer that case. Yeah, so yeah, just get with the court coordinator. They're gonna reset, they're gonna transfer the case next door. Okay,
Thank you.
nice seeing you. Have a blessed day.
Seeing you.
You have a blessed day as well, Mr. Johnson.
Yes.
Yeah, hold on a minute. Let me, okay, Mr. Gamble?
Criminal for Mr. Gilthorpe.
Oh, this was the bench trial, Your Honor.
Oh, did they add it on the docket today? Uh, I'm gonna put- Okay, here we go. Yeah, Jesus Gill. Okay. We ready? Oh, okay. Okay, because I think, yeah. Jefferson County Court, Illinois, 2 is back in session. The court is in session. It calls number M 332-614, case of style of state. Could y'all give me one of those, waiver of, jury trial strategy? It's right there, it should be in the first one, in the middle section, the first document. Yeah, just go ahead, y'all go down and sign that right quick. Mr. Galmore. Okay, this is cause number M 332-614, case of style of state of Texas versus Jesus Gill. Mr. Gill, is that your full name?
Yes, sir.
How are you doing, Mr. Gill?
Yourself.
I'm doing fine, thanks for asking. Now, Mr. Gill, you're representing your case by your attorney Jerry Gilthorpe. However, Mr. Gilthorpe is not here today. Standing in for Mr. Gilthorpe is his law partner, attorney Dustin Galmore. Does Mr. Galmore have your permission
Yes, sir.
to stand in for Mr. Gilthorpe?
Yes, sir.
Okay. Now, this case is set for what we call a bench trial. That is, you're waiving your right to a jury trial. Is that correct?
Yes.
All right. Now, state, are you ready to proceed?
We're ready, y'all.
Defense, are you ready?
Ready.
Okay. Ms. Porter, you may proceed.
I'm gonna start by reading it.
Yes.
In the name and by authority of the state of Texas, comes down to undersigned assistant criminal district attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents into the county court of law, Jefferson County, Texas, that in Jefferson County, Texas, Jesus Gill, hereafter styled the defendant heretofore on or about May the 17th, 2022, did then and there unlawfully, intentionally, and knowingly violate the terms of an order issued by Judge Larry Thorne of the 317th District Court of Jefferson County, Texas, on May the 10th, 2022, under the authority of Chapter 85 of the Texas Family Code and Article 17.292 of the Texas Penal Code, by intentionally and knowingly going within 1,000 feet of Yasica Gill, the person that's described in the aforesaid protective order against the peace and dignity of the state, that's signed by the Assistant Criminal District Attorney, Jefferson County, Texas.
Mr. Gill, how do you plead? Not guilty, guilty, or no contest?
Not guilty.
Okay. State, would you like to make an opening statement?
State's gonna waive oath.
Defense?
Go ahead, Judge.
State, you may call your first witness.
The state's gonna call Yasica Gill.
The waiver.
Yasica Gill.
Yasica Gill. Would you please call Yasica Gill? You have the same. Okay, no response. State, you can call your next witness.
State has no further witnesses, however, I would like to make a brief statement.
You may make your statement.
If the state has made continuous attempts to locate Yasica Gill, we've left messages, sent out letters, and also, at some point, it seems like the number has been blocked, my office number has been blocked. I've even tried to call her again this morning without any return.
Okay, does the state rest?
Statements.
Defense?
Defense version restricted verdict, not guilty.
That motion will be granted. Mr. Gill, you have been acquitted of these charges. Our court coordinator will draft up a judgment. You'll be able to get a copy of the judgment from your attorney when you leave. Okay, so it should take a few minutes to draft that up.
Thank you.
Okay, y'all have a blessed day.
Judge,
You have another one?
I do not, but I was wondering if, I looked online, I don't see the next week's dockets printed yet.
You can talk to one there.
I do have, maybe a conflict Monday morning, and so, I'll talk to him.
Yeah.
And I'm ready.
Mr. Vasquez, you have a case on the docket?
No, Your Honor.
Oh, okay.
Thank you, Judge. We're discussing on that.
I know. I was just seeing the lawyers here. Do you bring your docket to let us know who's here? This is cause number 23 CCR 2222. Case of Style State of Texas versus James Ray Collins. Mr. Collins, is that your full name?
Yes, sir.
How are you doing, Mr. Collins?
I'm blessed, yeah.
Well, that's good. Can't be better than being blessed. Now, Mr. Collins, you're represented in your case by your Attorney Giles Cole. Attorney Cole, how are you doing?
Great job, rock and roll.
And Mr. Cole, what is your announcement in Mr. Collins' case?
I just related my offer to him, so we like to provide like for a short reset.
Okay.
Reset now.
Well, State, do you have any objections?
No objection, Your Honor.
Okay. You say you're gonna reset it to June 12th?
Yes.
Okay. June. Yeah. Mr. Collins, your case is gonna be reset to June 12th, 2024. The attorney is gonna get your reset. Once you get your reset from your attorney, you're free to go, and you have a blessed day.
Thank you.
All right. All right,
Thank you.
all right. Yeah, you're free to go. Ms. Grove, you here on, Rayvon Gallo?
Yes, sir. He's in custody. It's my understanding that they are having a motion to revoke probation hearing today in drug court.
On him? Okay.
Yes, sir. And I think that he'll either be revoked or he won't be, but I think he would be ready to dispose of this case. And I've talked to Mr. Hugo, we got a plea bargain agreement.
Okay,
We'll
okay.
just-
So what we'll do, we'll just, see what happens with the felony case.
Well, if we could, Judge, I mean, I know tomorrow is Thursday, but if we could get him out of jail in this case.
But you say he has an MTRP hearing today?
Yes, sir.
Okay, it's on a felony case?
In drug
Yes,
court,
sir.
Your
In
Honor.
drug court.
Okay,
Or maybe if we could reset him for tomorrow and bring him
we
back,
can do that.
we could maybe get it disposed of.
Okay, okay,
I
we'll,
know it's the last day of the week, but
okay, we'll do that. We'll reset it for tomorrow.
it'd mean a lot to him if he could get out of jail for Easter, I think.
I'll reset it, Judge.
Okay, it's gonna be reset, till tomorrow?
Yes, sir.
All right.
Okay.
All right, Mr. Grove, I think this is the only case. You're free to go. You have a
Yes,
blessed
sir, I
day.
think it is. Thank you, Your Honor.
You're welcome. Mr. Wilson, your full name is Nathan Wilson. How you doing, Mr. Wilson? I'm doing fine, thanks for asking. Mr. Wilson, you're represented by your Attorney Donald Boudreaux. Attorney Boudreaux, what is your announcements in Mr. Wilson's cases?
Judge, we would probably be able to work this thing out, if I talk to the DA.
Okay.
because,
You want me to hold on it?
um,
You're gonna try to work that out today?
Yes.
Okay, just have a seat, Mr. Wilson, and we'll call you back up.
I have it on. Let me go back. No, I'm gonna call this one. I'm trying to put it back. This is the drum. I got it. Okay. Okay. Got it.
Oh, did we ever catch up with, Mr. Grove?
Yes, he said, he had a prior engagement this evening, so he said.
Oh, okay. Okay, let's do a pro se. Tyrus Sias. Mr. Sias, your full name is Tyrus Trevon Sias. How are you doing, Mr. Sias? I'm doing fine, thanks for asking. Yes. See. Okay, Mr. Sias, you appeared in court on January 9th, 2024. At that time, you stated that you wanted your case reset so that you can hire your own attorney. Have you hired your attorney?
No, Friday.
Oh, you're gonna meet with your attorney Friday?
Yes.
Okay, so what we're gonna do is, reset this case. Give us a standard reset. Give him the opportunity to hire his attorney.
June 12th.
Okay, this case is gonna be reset to June 12th, 2024. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. You're welcome. Ambrasia DeCary Roy. This is cause number M333-316. Case is filed with State of Texas versus Ambrasia DeCary Roy. Ms. Roy, is that your full name?
Yes, sir.
How are you doing, Ms. Roy?
Good, how are you?
I'm doing fine, thanks for asking. Ms. Roy. We appeared in court on September 12th, 2023, is that correct? And at that time, you stated that you wanted to waive your right to an attorney and represent yourself. Is that correct?
What case is it?
Hmm?
What case is it?
What case is it? I didn't hear you.
That's must be two of them.
There are.
Oh, yeah, I see two cases. This is a 333-316, which is the driving while intoxicated case. Let me see. Oh, let's see if she changed her mind. Well, she appeared again on January 10th, 2024. And at that time, you stated you want your case reset to hire your own attorney. Okay. Have you hired your attorney?
Yes, I did.
Who did you hire?
That's the job. They're doing-
Do we have a letter of representation from,
Mr. Adams came in this morning and said that, she hadn't hired him yet, but she's planning on hiring.
that's two different things. Planning on hiring and hiring is not the same. You said you hired him. He said you didn't hire him, you planning on hiring him.
Well, I had talked to him.
Okay, that's all I need. I just need to know whether you hired him or you didn't hire him. So you intending on hiring him? How much time do you need to hire him? You said, okay, little,
Um,
okay, one standard reset.
what did you do, 12?
Okay, it's gonna be more than a month. Okay. So she's gonna reset you. You need to take that gum out your mouth. You chewing gum? Huh?
Yes.
Okay. There's a trash can to the right. Yeah. Okay. So your case is gonna be reset. What date is that?
June 12.
June 12th, to give you an opportunity to hire Mr. Adams. Once Mr. Adams is hired, he's going to send the court a letter of representation informing the court that he has been hired by you to represent you. Okay? And typically what typically happens when he sends a letter of representation, the case usually is reset. Okay? But until then, your case is set for June 12th, 2024, to give you opportunity to hire Mr. Adams. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. Please stand on the forehead. Before we make sure we got bond conditions, let me see. Before she, I need to make sure she got bond conditions. I don't see none. Oh, no. Hold on a minute. Let me look at the next one. Uh-oh. Yeah, Odyssey just went down on me. Wow. Ms. Roy, the bailiff has just handed you a document that is titled Standby Conditions in County Court at Law Number 2. Do you see that title?
Yes.
Okay, I'm going to go over these bond conditions, which it reads as follows. Following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. The defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Number 2, the defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of a pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply because this is not a DWI. Second, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Texas Code of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Ms. Roy, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Your case has been reset until June 12th, 2024. You have your reset, you're free to go, and you have a blessed day.
Thank you.
You're welcome. Miss Jennifer, what was the person's name?
An early termination review.
Is that on
Sharon Aubrey.
Aubrey? Okay, this is cause number 2. This is cause number M334284, case of style of state of Texas versus Sharon Aubrey. This is an early termination of probation. Let's see.
It's not, it's not. I think this is something, you talk to him. Okay.
I know you had do you have a copy of her, early termination? It's not here in the, with my paperwork. I guess I could just use yours.
Over.
Yeah, okay. Okay, court has before the copy of the further adjudication order dismissal. In this order that is recommended by Jennifer Reeves, it states that the defendant has satisfactorily served 1/3 of assessed term and has not been involved in any criminal offenses during said community supervision term. Let's see. The
She's
judgment.
actually done half of her term.
Okay, she was placed on probation August 4th, 2023, is that correct?
Yes, sir.
And let's see. And her terms, no criminal offense or injurious mishaps. And, she was ordered to pay fine and court costs totaling $842. The general fine was, $500 and the court cost was $342. So she's paid all of that.
Yes, Your Honor.
She's also paid the attorney's fees,
Yes, Your Honor.
probation fees, urinalysis fee.
Those are current, Your Honor.
Okay, so the, probation fee is just current too.
It's current, yes, sir.
Okay. And the urinalysis fee, because those are assessed on a monthly basis.
Yes, sir,
While
but they're
the
current.
person is on probation. Is that correct?
Yes, sir.
And she was required to perform 45 hours of community service. She completed those 45 hours. Is that
Yes,
correct?
sir.
Let's see. And this offense was a theft, class B.
Yes.
And she was given deferred adjudicated probation. Okay, so she did about 7 months of the 12, is that correct? Yeah. You have anything else that you'd like to, offer up to the court?
Yes, Your Honor, she has been full-time employed with the ISD as a Medicaid specialist, through their administration office. She's also reported, I've never had a problem with her even rescheduling. She reports on time. Very pleasant, no issues at all.
Okay, state?
Given the fact that the defendant has completed all conditions of probation, has done half her term, is current on payment, is employed, and always reports on time, I state sees no reason to oppose.
Okay, so the court is going to grant the deferred adjudication order dismissal on today's date, 27th day of March of 2024. Okay. That's it.
Thank you, Your
All
Honor.
right. See you later, Ms. Reeves.
Yes, sir.
Was this the one that was deleted? Okay, court is in session to cause number 23 CCCV 0614. Case of South State of Texas versus Deja Brown. Ms. Brown, your full name is Deja Brown?
Yes.
How are you doing, Ms. Brown?
I'm all right.
I'm doing fine. Thanks for asking. Ms. Brown, would you please raise your right hand? Ms. Brown, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Brown, you may put your hand down. Ms. Brown, last time that you were here, there were some things that were missing in the original petition. However, you did file an amended petition.
Yes.
Is that correct?
Yes.
And I have a copy of this amended petition. Okay. Let's see. Let's see, a copy of the, And Mr. Have you had a chance to review the petition for non-disclosure?
At the last court date, I reviewed the petition and there was, if I recall correctly, the only issue that we solved it was the fact that there was a document missing.
Right. There's the other case, it was. Oh, here it is. Was a document showing that she received deferred probation. Because I think she had previously attached the dismissal. Right. And there was a date missing regarding the start date of the deferred adjudication, which was November 30th of 2020. And that has been, all of those corrections have been made. And we looked at the document. I think we may have asked her, I think we did everything that was required by law. She satisfied all the other requirements. I think we even asked her why it would be in the best interest of justice that that she be given a non-disclosure. Is that correct?
Yes.
Okay. So if there's no objections, the court is going to grant this order of non-disclosure.
No objection, Your Honor.
Okay, petition order of non-disclosure. Where's, I don't see I'm looking for the petition. I'm gonna need a copy of the order.
Okay.
To sign. Ms. Brown, can you have a seat in that first chair? If you're looking for the order, you'll be able to get a copy of it. I'll just set this right here. There's no order?
One that they emailed us. The information.
Okay, this is cause number 23CCCV 0492, case of style of state of Texas versus Taisha Ricole Bowman. Ms. Bowman, is that your full name? Ms. Bowman, would you please raise your right hand? Ms. Bowman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Bowman, you may put your hand down. How are you doing, Ms. Bowman? You doing good? That's good. Now, Ms. Bowman, you appeared in court before on this petition for non-disclosure, is that correct?
Correct.
And I think at the time that you appeared, the district attorney's office pointed out the fact that you had received, I guess, a felony uh, conviction sometime after you were discharged from this probation. Is that correct?
Correct.
Okay. And I think Mr. Hubel, you pointed that out. I think you looked at the criminal history and you found that to be true. Is that correct?
That's correct, Your Honor.
Now, and Mr. Hubel, you said the state was against the non-disclosure based on that.
That is correct.
Okay. And you're asking for a non-disclosure under section 411.0725. Let's see, the apply only to person deferred education who is not eligible. Okay. Not based on provision. Let's see. On what provision does it say that because of her latter conviction that she's not eligible for non-disclosure? Mr. Hubel.
So, let's see. That's A2, Your Honor. And it states that the defendant has the section only applies to a person who was placed on deferred adjudication under subchapter C, chapter 42A, Code of Criminal Procedure for misdemeanor. And so A2 specifically says has never been previously convicted or placed on deferred adjudication for, hold on. I think I may have been looking at the wrong section on it. Here,
Is that 411.074? Let's see. First amendment would be granted.
I think the issue may have been family violence, Your Honor.
The offense is a This is an evading arrest. Okay, now,
Yeah, the subsequent offense was,
person may not be granted following this subsection and is not entitled to petition.
and I think the question is,
The person requests to order a non-disclosure for who has been previously convicted of or placed on for an offense requiring as a sex offender. Any other offense involving family violence.
I think the question is
Person may
whether the language previously convicted refers to the period of deferred adjudication or when the individual makes the motion for non-disclosure.
All right. Okay, so we do know that she was subsequently convicted. He was convicted after this probationary period ended. Is that correct?
Correct.
Now, was she convicted or was she given,
Deferred
or was she given deferred?
Deferred.
A person may be granted order under this and when applicable is entitled to this receipt. If during the period of pronouncement, a person on community supervision, including deferred adjudication, period for was to end any other. Not convicted or placed on. Yeah, or placed on deferred adjudication for any offense other than the offense that is punishable by fine only. Were you able to find any cases on this matter regarding whether or not the previous, prior conviction meant prior to getting on this probation or prior to?
State would only argue that the language in the applicable waiting period applies to the like, that new.
Yeah, but the waiting period actually, the discharge. The dismissal, okay. There's a 2-year wait period if it was if the offense was fell under one of these other categories, and I don't think hers fell under one of the categories of being an assault. Yeah, I don't see it, the language. Yeah, I don't see where the language says that it has to be. I mean, a waiting period, if she had a waiting period beyond up to 2 years, but her waiting period, she was eligible on the day that she received the discharge, her discharge on this case. And it states, let's see, 25, it says they may petition the court to place on deferred adjudication for an offer, regardless of whether the defendant has been previously convicted or placed on deferred adjudication for another offense. So they say except for 411.074, we do know that she did not have a previous conviction or a previous deferred adjudication before she was placed on this probation. Is that correct? That's correct, because it came afterwards, right? And so when we go to 411.074, where is it? Here we go. Person may grant order. of this provision is entitled to petition the court to receive the order only if during the period after the court pronounced sentence or placed the person on community supervision, including deferred. Or person, reaching of the person sentence of community supervision. The person is not convicted or placed on deferred adjudicated community supervision for any offense other than a traffic. She was
Yeah.
placed on deferred for, what was the offense?
It was
aggravated
assault.
It was aggravated assault. A person may not be granted order of community supervision under this provision and is not entitled to petition the court if the person requests the order now for, or the person has been previously convicted or placed on deferred adjudication for.
Also,
The question is previously convicted.
I think we were mostly focused on our, on the felony cases last time that we were in court.
All right.
May I ask Ms. Bowman a question?
Yes.
Did you have a, that case from 2008?
Oh, okay. Now this offense,
This is the event from 2012, right?
this was 12, yeah. Yeah, this was a 12 case. Beginning in October. Office was October. The probation started October 2nd, 2012. And it ended April 30th of 2013. Terrence, you got an early release? Yes. April 30, 2013. And she did 1/3 of the time.
On for, further inspection, the issue is that there need to be a prior conviction or deferred adjudication. I am seeing an offense from 2008.
Okay, so we need to verify whether or not that was a conviction. You think that you seen one as a conviction in 2008?
Yes, Your Honor, 3/18/2008. It was it was a theft.
Okay. So that would be a prior conviction, which would make her, let's see, well, I think the statute says regardless of a prior conviction. Irregardless of a prior, here we go.
If that's the case, then she'd be fine.
Yeah, that says satisfy the requirements, may petition the court, order, except as provided for the code under the sub, regardless of whether the defendant has been previously convicted or placed on deferred for another offense. That's under 411.0725C. So even if she had a previous convicted or placed on deferred, she would be eligible except for the requirements of section 411.074.
Yeah, the previous conviction you're fine.
Yeah, she'll be fine with a previous conviction. I think they gave her a non-disclosure in a felony case, is that correct?
I had 2 dismissals and a non-disclosure.
Right, you had a non-disclosure, but even though she had this case before the felony case, she was still eligible. So it's not necessarily the previous convicted. I think the objection that the state made the last time you're saying that, well, she had a subsequent conviction that made her ineligible. That's what I remember from the last hearing. Is what I don't see in the statute. I was looking for that language in the statute that says the subsequent conviction makes her ineligible. Okay, Mr. Bowman, just have a seat. We're gonna make sure we're getting close to it. We should be able to resolve it in a few minutes. All right. Come on up. Okay, this is cause number 23CCCR 2412, case of style of state of Texas versus Mark Andrew Crocker. Mr. Crocker, is that your full name? How are you doing, Mr. Crocker?
Good.
I'm doing fine. Mr. Crocker, you're represented in your case by your attorney Tom Burbank. Attorney Burbank, how are you doing? That's good. Mr. Burbank, what is your announcement in Mr. Crocker's case?
Asking for a reset so I can have some time to talk to, Mr. Crocker and also talk to the district attorney. Try to get this case settled or put it in the right direction.
Oh, okay, give us a reset date. Okay, this case is going to be reset for June 12th, 2024. Mr. Crocker, stay in contact with your attorney. Once you get your reset, you're free to go and you have a blessed day. Okay.
I'll talk to you soon.
Next defendant is Andrew Chase Hoosier. Cause number 23CCCR 0430 and cause number 23CCCR 0433. Both cases in style of state of Texas versus Andrew Chase Hoosier. Mr. Hoosier, is that your full name? Okay, Mr. Hoosier, how are you doing? Oh, that's fine. Let's see, got Mr. Hoosier. So 30. Oh, here we go. Mr. Hoosier, you're represented in your cases by your attorney Tom Burbank, Attorney Burbank. What is your announcement in Mr. Hoosier's cases?
Your Honor, he is current felony, though we do have a hearing that's continued from today. It's only a administrative issue. I would ask that we reset it probably tomorrow when we reset the trial date. because it is on the trial, or will be on the trial docket. But you have a court date of tomorrow morning. It's been reset. He just came from CDC. And they reset it till tomorrow because of an administrative
Okay.
question that he had. And so I'm asking that instead of, don't set it tomorrow because nothing's going to be taken care of. If you'd wait till after tomorrow to reset it on the next court date, because this will be dispositive as soon as we take care of the file.
Okay, so we'll just wait until they reset the case, and then we set it on the same day.
Tomorrow, CDC will reset it, to whatever date, and I would ask that it be placed on that date.
Okay. State, you have any objections?
No objections, Your Honor.
Okay, we'll reset it then. Okay, Mr. Hoosier, just stay in contact with your attorney. You're free to go. You have a blessed day. Next case. Ashley Alfaro.
Hello,
How you doing?
I'm good, how are you?
Okay. This is cause numbers M2399263 and cause number M323465. Both cases are styled the state of Texas versus Ashley Elizabeth Alfaro. Ms. Alfaro, is that your full name?
It is, sir.
How are you doing, Ms. Alfaro?
I'm okay for this to be over.
I understand. Ms. Alfaro, you represented in your case by your attorney Tom Burbank, Attorney Burbank. I have before me a motion for authorization to expend funds for review of mental health records.
Well, it's actually to get it's actually to get an expert in anticipation of trial, if we have to go to trial on this. To get records and also trial. Brief recap, Your Honor, Ms. Alfaro was under the mental health caseload. It's been a number of years.
4 years.
4 years. With the anticipation that she successfully completed it. Something good might result in this, i.e. probably a dismissal. Last time we were here, I know it was a brand new prosecutor that was here. Needed some time to check on something, but in anticipation that they do not want to do that because of her mental health issues, then we're going to have to try this. And so I'm asking for funds. If one is to give the state, if that's the avenue they want to go down, and number two, then I will file the appropriate motion again with specific amounts and doctors that I will have in order to be ready for trial.
Okay, they just would like to make a brief statement. If you're prepared to go to trial and that's where we're heading, that's one thing, but it seems a little premature because he does know the direction of the case. If you would like to converse more about the case after.
We've conversed all we wanted to. This was an issue the last time we were in court. I'm not trying to be mean, but she cannot plead to anything because of her mental health status. And that's the avenue, the only avenue that we have. If you're not going to agree to what you've done in the past with other clients.
Okay, but I haven't conversed with you at all, so I don't know who you conversed with, but I haven't talked to you.
Gentleman standing right behind you.
And I can speak to what was said last time in court if y'all would like.
Now, let me do this. Now, if y'all need time to talk, that's fine, but we're not gonna get before the bench and negotiate because the court does not get involved in any negotiations between the parties. And so if y'all need to talk more, we can. I was just looking at the motion, the way it was worded.
Right, and I looked at that as well.
And now you saying you need an expert. This one is saying, the motion is not necessarily saying that. It's just saying asking for funds to review, for consultation, I mean, but there's nothing really specific in this motion. But
Well, if I may respond to that, Judge, is because I believe the state had said at the last hearing that they had to contact somebody or make some determination because it was his first time of looking at the file of what they were going to do. And so in anticipation of that and the amount of time that's necessary in order to get an expert, I just wanted to put that out to show the court that that's what I'm going to need to do if I believe they don't do the right thing.
okay,
Because it's been going on such a long time.
Yeah.
And she's such
but
a
I mean,
flying colors.
okay.
Doing great.
But I think, what would be appropriate, if you file a motion, you're gonna have to file what's called an ACI motion. Okay,
AK versus Oklahoma.
Oklahoma, right?
Absolutely.
I mean, but this is not what this is, so,
Well, and Judge, again, I
Right.
would do that, but if they're not going to do what hopefully they'll
Well,
do.
you haven't given us me an opportunity. I'm on the case now. So if you want to
Okay,
give an
well, I
opportunity.
didn't know you were on the case until just like
Well,
right
you're
now.
right now. I'm on the case now. So
Okay.
give me an opportunity.
okay. So,
Give me an opportunity to look at it. We can
Well,
talk.
I mean, it's
All
been
right.
on file since January.
okay, well, we're
But I
gonna,
haven't been here since then.
okay, so let me do this here. We're gonna give y'all, we'll get a quick turnaround for y'all to talk. And I know Mr. Farrow, you've come a long way.
Thank you, Judge, but I'm exhausted.
I understand, but just,
Calling my
Let-
godmother and every single
okay.
Monday.
I know you've been doing a great job.
That's a lot of work.
Okay, just hang on and don't hang up. Okay, so just hang on there, just hang in there. Hey, seem like we're getting close to resolution.
I just completed a program that you designed or that the courts designed, a 12-week program to go to my counselor, Tristan, at MHMR for 12 weeks. I completed that program, but the district attorney did not have it in the court, in their records.
Understand, but you have a able attorney here. He has, brought that information before the court. But I think we may be close to a resolution. And I'm going to give, the prosecutor an opportunity to talk to your attorney to see if we can get it resolved. And we'll give you a quick turnaround. You want a standard reset, 30 days or just something so we can, so y'all can get talking?
Get it done this morning.
Okay. Well, what we'll do, we'll just put it on hold. Okay?
Okay.
All right, we'll do that.
Hold on a minute. Have a seat.
Okay, thank you.
Jefferson County Court at law number 2 is back in session and cause number M322-308. Case style of state of Texas versus Tatiana Deshawn Thomas. Tatiana Thomas was scheduled to be in court this morning at 9 AM for the court's announcement docket at about 9 AM. The close bail called the name of Tatiana Thomas at the courthouse door. She did not answer. She has not appeared in court since the court has been in session. The time now is 11:52 AM on today's date of March 27, 2024. Mr. Bailey, would you please call the name of Tatiana Thomas at the courthouse door?
No response to that name, Your Honor.
Okay, Tatiana Thomas' name was just called again at the courthouse door by the post bailiff. Tatiana Thomas did not answer. A reasonable time has passed to give Ms. Thomas the opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Tatiana Thomas' bond will be forfeited and a warrant should be issued for her arrest in clause number 322-308. Okay, Sharon R, on page 6, the announcement docket. What?
That's what you signed that deferred adjudication.
Okay, that was an early release. Jerry and Elam, he was set for a felony.
These are in custody.
Okay. Ramses Morales is in custody. Ramses Concepcion Morales Jr. Let's see, that's everybody on the announcement docket. And with the exception of Mr. Wilson. And we have everybody with the exception of Mr. Alfaro on the hearing docket. Okay, so we're just leaving Holmes, Ms. Alfaro, Mr. Wilson. Okay, court will be in recess. Okay, court is gonna grant your petition. Congratulations. You should be able to get a copy of this petition from, a copy of the order, that is, from the county clerk's office, probably sometime tomorrow. Okay? All right, you're free to go. You have a blessed day.
Thank you.
You're welcome. Michelle. Miss Erica. Yes. Yes, that's 300. Because it's gonna be one is a dismissal, right? It's not 250. Yeah, 2 cases. Okay, I know you're tired, but you. All right, don't be yawning in front of the bench. All right. Now, Mr. Woodrow, you ready to proceed?
No contendering.
Okay. All right, this is cause numbers.
It's a resisting arrest charge, Judge.
Yeah, okay, we have Mr. Wilson on 2 cases. First case is cause number 23 CCCR 1954. Second case is cause number 23 CCCR 2047. Both cases are style of state of Texas versus Nathan Wilson. Mr. Wilson, is that your full name? Mr. Wilson, would you please raise your right hand? Mr. Wilson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God. Mr. Wilson, you may put your hand down. How are you doing, Mr. Wilson? I'm doing fine. Thanks for asking. Mr. Wilson, you represented in your case by your attorney, Attorney Don Boudreaux, Attorney Boudreaux. Do you waive a record in Mr. Wilson's cases?
Yes, sir.
Mr. Wilson, I have before me in cause number 23 CCCR 1954, a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Wilson, it alleges that you, Nathan Wilson, on or about September 4th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Wilson, do you understand what you have been charged with? And to this charge, Mr. Wilson, how do you plead guilty, not guilty, and no contest?
No contest.
Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Wilson, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked. No contender, which means no contest, as you place your initials on this document.
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification, Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And at the bottom of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Wilson, before you signed and initial all of these documents that I just showed you, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Wilson, are you a citizen of the United States?
Yes, sir.
Stay up for stage 1.
Any objections, Mr. Boudreaux?
No, sir.
No objections. State's exhibit number 1 will be admitted. Court will also take judicial notice of the court's file. Mr. Boudreaux, you've advised and counseled Mr. Wilson. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, sir.
And Mr. Boudreaux, your attorney, Mr. Wilson, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Wilson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The agreement, for a plea of guilty or no contest, the state has offered 1 year deferred probation with $500 fine, 60 hours community service, and the dismissal of the UCW case for forfeiture.
Okay. Mr. Wilson, the state is offering that you serve 1 year deferred adjudicated probation. What is this, court cost? $277.
Thank you.
Okay, so Wilson, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500. You'll be required to pay court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee $15. You also be required to reimburse Jefferson County $300 for the court-appointed attorney's fees. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $181 a month. Will you be able to pay the $181 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service, and the state will be dismissing cause number 23 CCCR 2047 for forfeiture of the weapon in that case. And I have before me a motion to forfeit the weapon in cause number 23 CCCR 23 CCCR 2047. You recognize this motion to forfeit?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
Now, before you sign this document, did your attorney go over this document with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. And you're asking the court to forfeit the weapon to the Port Arthur Police Department?
Yes, sir.
Is that correct? And the court is going to grant this motion. Court is forfeiting the weapon in cause number 23 CCCR 2047. Now, Mr. Wilson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair, or in your case is fair and just?
It's fair.
And do you accept it?
Yes, sir, I do.
Okay, Mr. Wilson, I'll follow the plea bargain agreement that you have made with the state. Mr. Wilson, if you successfully complete the probationary period in clause number 23 CCCR 1954, this case will be dismissed. It would not result in a conviction in your record. And you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Mr. Wilson, you're gonna stand in front of just have a seat in the chair.
Yes,
And then when they call you back up to the window, come up to the window. And once you could finish at the window, you'll be free to go and you have a blessed day.
yes, sir. Thanks.
You're welcome. And-
You signed the dismissal. And you-
Yes, I'm signing the dismissal right now.
Thank you, Judge.
You're welcome.
I'm also submitted dismissal on an off-docket matter, and I believe the name is Martin Parker.
I think I signed that dismissal as well.
Yeah. That one was refiled.
Okay. Okay. Now, this will conclude the calling of the court's docket. In County Court at law number 2, those 2 dockets was the hearing docket and the announcement docket. And this will conclude the cases in both dockets in County Court at law number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Mr. Boudreaux and prosecutors, you are excused.
Got it done, didn't we?